Reading every privacy policy you encounter in a single year would consume approximately 30 working days. That figure comes from Lori Faith Cranor and Alicia McDonald, researchers who in 2008 published a paper titled The Cost of Reading Privacy Policies. They did the arithmetic. The average privacy policy takes about 29 minutes to read. Multiply that across every website and app you touch in a year, and 76 working days isn't an exaggeration. On paper, a privacy policy is a contract. It tells you what data a company collects, how it uses that data, and who it shares it with. On paper, this is a perfectly reasonable system of informed consent. The legal architecture beneath all of this is called the notice and choice principle. It underpins privacy law in both the United States and Europe. Notice means a policy exists. Choice means you clicked a button. In practice, notice and choice assumes you read the notice before making the choice. That assumption is doing an extraordinary amount of heavy lifting for a document most people scroll past in under 3 seconds. Privacy policies are written in what researchers politely call complex legal language. The less polite term is legalese. Either way, the average consumer isn't the intended reader. The intended reader is a corporate attorney. Most people, confronted with a privacy policy, choose speed over comprehension. That's not laziness. It's a rational response to an irrational demand. Nobody has 76 working days to spare. Which raises a question worth asking. Does anyone read them? Researchers have a term for the people who do. They call them the informed minority. The name implies everything about the size of the group. The informed minority reads the policy. They understand what they're agreeing to. And then, in most cases, they agree anyway, because declining means not using the service. The choice was always decorative. Under the notice and choice framework, simply using a website after a policy is posted constitutes implicit consent. You consented by arriving. The policy didn't need to be read. It needed to exist. Here's the part that tends to stop people. Federal law in the United States doesn't require all online businesses to have a privacy policy. The document you're not reading isn't always legally mandatory. State laws, sector-specific rules, and platform mandates push businesses toward posting policies. Apple's App Store Review Guidelines, Section 5.1.1, introduced in 2013, required every app handling user data to post a privacy policy or face removal. The federal mandate most people assume exists isn't there. A common misconception deserves correcting. The presence of a privacy policy doesn't mean a company actively protects your privacy. It means a company has posted a document. Those aren't the same thing. Follow the incentive. Companies benefit directly from consumers not reading privacy policies. Less scrutiny means more operational latitude. The complexity of these documents isn't an accident of poor writing. The technical term for this dynamic is information asymmetry. One party to the agreement, the company, knows exactly what the policy says. The other party, you, has agreed to a document you haven't read. Return to that 76-day figure. If the system were designed for users to actually read these documents, the documents would be shorter and simpler. They're neither. That's a design choice, not an oversight. A 2012 study by Lori Faith Cranor and colleagues at Carnegie Mellon found that longer, more complex privacy policies correlate with weaker user understanding and reduced data protection in practice. Complexity isn't a neutral property of legal documents. It has consequences. Think about the last time you downloaded an app. A prompt appeared. You tapped Agree. The policy behind that tap was, on average, a 2.5-hour document. That 1-second tap may have authorized data collection, third-party sharing, behavioral profiling, and location tracking. The policy said so. Somewhere in the document, in the section after the section you didn't read. In 2014, A U.S. District Court ruled in Wynn versus Barnes & Noble that a user who hadn't read the website's terms of service was not bound by its arbitration clause due to insufficient notice.
The system, as designed,
Doesn't optimize for informed consent. It optimizes for documented consent. The form exists, the box is checked, the audit is clean, the process is complete. Whether you understood anything is beside the point. Meaningful reform would require shorter policies, plain language requirements, or genuine opt-in mechanisms. The Consent Act, introduced in the U.S. Senate in 2018, proposed exactly these changes. It never reached a floor vote. Follow the incentive. The incentive doesn't point toward reform. Europe's General Data Protection Regulation, enacted in 2018, emphasizes data protection by design and default, rather than strengthening the notice and choice framework. Ask a different question. What would genuine informed consent look like in a digital context? It would require time, comprehension, and a real alternative. Currently, the alternative is not using the internet. That's not a choice. That's a wall. Cranor and McDonald estimated that if Americans actually read every policy they encountered, the aggregate national cost would reach hundreds of billions of dollars in time value annually. Consent at scale is economically impossible. A 2019 Pew Research Center survey found that 9% of American adults say they always read a company's privacy policy before agreeing to it. 73% said they rarely or never do. The gap between the legal fiction of consent and actual user behavior isn't a rounding error. 76 working days. That number was never a problem to be solved. It was a measurement of how far the system had drifted from its stated purpose. The policies were never written to be read. They were written to be posted. The result is a system that produces documented ignorance at scale. Every user technically consented. No user was meaningfully informed. The paperwork is immaculate. The audit is clean. The form was completed correctly. One practical response is available to an individual. Use tools that do the reading for you. Browser extensions and the nonprofit service Terms of Service Didn't Read, known as TOSDR, publish plain language policy summaries and letter grade ratings for hundreds of major platforms. In 2019, the FTC fined Facebook $5 billion, the largest privacy penalty in U.S. history at the time, not for writing a confusing policy, but for violating its own stated terms. The enforcement targeted the company's liability exposure, not user comprehension. The document existed. That was the standard. 76 working days. The number hasn't changed. The policies haven't shortened. The incentive hasn't shifted. The system is functioning exactly as designed. That is perhaps the most informative thing about it. This audit is complete. The findings, as always, may be ignored.